Assalamualaikum warahmatullahi wabarakatuh. My name is DANIAL KAMARUL ZALI. Okay, today I want to talk about the difference between Director General of Trade Unions and Director General of Industrial Relations. Okay, for the first part is DGTU. A crucial role within the trade union is held by the Director General, who is responsible for leading the union towards operational success while tirelessly advocating for the rights of workers. Endowed with executive powers, the Director General carries significant responsibilities including negotiating collective bargaining agreement, resolving conflicts between workers and management, and ensuring equitable compensation and benefits for employees among other operational tasks. Effective communication skills are essential for success in this position. The Director General must be adept at conveying the organization's view internally to the union members and externally when addressing authorities or the other organization. A strong grasp of labor laws, policies, as well as leadership, management, and exceptional communication skills are imperative. Establishing and nurturing strong relationships with fellow union officials, stakeholders, and labor organization is vital for an effective Director General. The guidance and supports provided by leaders and advocates play a vital role in ensuring that workers receive a fair treatment and that their concerns are effectively communicated. For the Director General of Industrial Relations, hold a senior government position with the responsibility of overseeing and regulating the relationship between employers, and trade unions within a specific country or region. This role involves close collaboration with government official, trade unions, and employers groups to develop and implement labor laws and policies that safeguard workers' rights while supporting the growth and sustainability of businesses. The Director General of Industrial Relations assumes a wide range of responsibilities, including the supervision of collective bargaining agreements, resolution of labor management disputes, monitoring of labor market trends, and conducting research to inform policy development. They are also responsible for providing guidance and counsel to the government official on matters related to industrial relations and labor laws. To excel in this role, the Director General of Industrial Relations must possess in-depth understanding of labor laws, collective bargaining practices, and employment regulation. Exceptional communication and negotiation skills are crucial for effectively addressing the needs of diverse stakeholders, including workers, employees, and government agencies. Ultimately, the Director General of Industrial Relations play a critical role in promoting equitable labor practices, safeguarding workers' rights, and fostering the ongoing prosperity of witnesses within the tribe or region, within country or region. That's all for me. Thank you.
Hello, Assalamualaikum. My name is MULKAN bin SAPUAN. My metric number is 20214819, and I am going to give a talk about what I am going to differentiate the roles of Director General of Trade Union and Director General of Industrial Relation. So the first role power that I am going to differentiate is the power to register trade union. DGTU, or also known as Director General of Trade Union, responsible to register trade union and regulate the activity under the Trade Union Act 1959. He also has the power to refuse register of trade union if they are likely to be used for unlawful purpose. As for DGIR, or also known as Director General Industrial Relation, they protect worker and there should be no strain or interfering by the employer if the employee want to join the trade union. And overall, the difference between DGTU and DGIR is DGTU has the power to grant and refuse registration of the trade union, while the DGIR does not have this specific power to grant or refuse the registration of trade union, but they protect the workers from gaining any restriction to join the Trade Union Act. Next is I am going to differentiate the next role, which is the power to control funds and account. DGTU has the power to control and audit the accounts of trade union and to make sure that the accounts are well managed and accordance to law and regulation. Based on Section 55 of Trade Union Act, DGTU have to ensure that all fund and trade union account are expended only for approved objective. Section 49 bracket 2A, Section 56 bracket 4 and Section 57 bracket 4 of Trade Union Act also mention that DGTU has the power to investigate the financial irregularities in trade union and take action to it if there is some problem about the Trade Union Act account. It is different between DGTU and DGIR role power in terms of the funds and account, because DGIR also have the power to control funds and account, which is and also they have the power to investigate financial irregularities, but only limited to industrial relation matter, and they do not have the power to relate any account that are hold by the DGTU in trade union. That's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is SHAHIRAH RAJIHA binti SARIPUDDIN. My number matric is 2021105623. So now I will present about the case of Kesatuan Kebangsaan Pekerja-Pekerja Bank NORS v Ketua Pengarah Kesatuan Sekerja NORS on 10 October 2013. Which is, this case is a landmark case around employment law in Malaysia. This case is centers on the question of whether unionized workers can be fired for taking part in a strike that the Industrial Relations Act of 1967 deems to be unlawful. A group of bank employees who were a part of National Union of Bank Employees Kesatuan Kebangsaan Pekerja-Pekerja Bank are at issue in this case. The workers went on strike in retaliation for their employer's refusal to acknowledge their union and engage in collective bargaining negotiations with them. The Director General of Industrial Relations ruled the strike to be unlawful, and as a result, the workers' employers fired them. The primary legal question in the case was whether the Industrial Relations Act of 1967 permitted the termination of employees for taking part in an unlawful strike. The workers claimed that their firing was unjustified and that they were entitled under the Constitution to unionize and engage in collective bargaining. On the other side, the employers said that because the workers had broken the terms of their employment agreement, they should have been fired. So, the High Court upheld the employees' claim that their firing was illegal and found in their favour. The Federal Constitution of Malaysia guarantees everyone the right to join a union and take part in industrial action. According to the court, any limitation on this freedom must be fair and justified. The Director General's decision to declare the strike illegal was judged by the court to be irrational and unjustified since it was not supported by any valid grounds. The court ruled that the workers' participation in the strike did not constitute a violation of their employment contract. The court observed the workers had conducted themselves lawfully and in good faith during their strike. So, the Industrial Relations Act Section 40, which states that employee may not be punished for taking part in union activities, was further cited by the court as providing protection for the employee's strike involvement. So, the decision in Kesatuan Kebangsaan Pekerja-Pekerja Bank NORS v Ketua Pengarah Kesatuan Sekerja NORS has significant implications for the rights of employees in Malaysia. The ruling upholds employees' basic freedom to unionize and take part in collective bargaining, subject only to legitimate and reasonable limitations. The judgment further emphasized how crucial the Industrial Relations Act is in defending the employee rights and preventing the retaliation against them for participating in union operations. So, in conclusion, the case of Kesatuan Kebangsaan Pekerja-Pekerja Bank NORS v Ketua Pengarah Kesatuan Sekerja NORS is a major decision which is that has strengthened the protection of employees' rights in Malaysia. So, the ruling has clarified that the extent of employees' rights to form unions and take part in collective bargaining, and it has emphasized the importance of employers upholding these rights. So that's all from me. Thank you.
Hi, my name is BATRISYIA. My student ID is 2021107689. I would like to talk about Kesatuan Pekerja. Pekerja yang dipecat boleh pegang jawatan. In case of Kesatuan Sekerja, according to the Labour Market Information and Analysis Institute, is the main factor worker being dismissed under Section 20. The relation for period from 2009 and 2018 issue in this case because of 30% layoff refer to termination of service due to adjustment and due to overstaffing. That's why there is Kesatuan Sekerja. The High Court and special power to the rules, the worker who has been dismissed can hold the official position by the trade union and submitted by the National Union of the Bank Employers, who ordered the cost to be borne by the plaintiff, said the court will not make a decision on the third appeal because the plaintiff have withdrawn the application. In the third appeal, the union sought a declaration that Solomon, who was appointed General Secretary on 7 August 2005 and was appointed to the same position on July 2008, was duly and legally appointed. Following to the decision of pekerja dipecat boleh pegang jawatan, Solomon will remain as new Secretary General until 2011. New filed the originating suit on 20 August 2008 after receiving a letter from trade union. In conclusion, the case Kesatuan Sekerja Pekerja boleh pegang jawatan is trade union in Malaysia have existed since the time of British rule. The trade union at the time functioned as an organisation that fought for the right of workers in various matters, especially related to the welfare of workers. The statute or law governing trade union at the time was not yet more restrictive, allowing anyone to join, particularly during the time of communists. Trade unions were a tactic utilized by communists who at the time caused the overthrow British control in Malaya.
In conclusion, trade unions are granted a variety of rights and power under the Trade Union Act of 1959 TUA. This is because only registered trade unions have access to all rights and the vast majority of powers. However, some of the authority that open to any union, registered or not, it should be remembered though that only law has given any unions are the rights and authority. The Director General of the Trade Union is also able to deregister the unions that have been found to be breaking the law or register newly formed unions. It examines a union's annual facts and generally look into any complaints made against a particular union. For instance, this is the allocation of the union will be funds, the union funds and the choice of union officials. Therefore, in the industrial relations, trade unions bargain to better pay for the workers. This is because they will be gained to better work in better working conditions such as more vacation time or increased health. also their mental and safety. Indirectly, it also gives many employees in general guidance and support in the workplace, as well as training to the new skills. Some people, particularly such as the employers of the businessmen, business people, and businesswomen, can blame unions for making excessive wages demands, driving up business costs, causing inflation, shielding incompetent workers, and interfering the crucial public service like transport and utilities, and even engaging in violent crimes. This is because people who support the unions can argue that employees need to be shielded from being taken advantages of the rapacious employers and unfair management practices. Finally, the employers should frequently withhold the employees' provident fund contribution for their employers' wages without remitting the money to the fund. For the example, that's all from our groups. Thank you to Madam Akma and to my classmate for hearing our presentation. Thank you so much.